Your Honor. I know, you know. No, don't see these things, you know, I don't have to try, but like, I do with them. Yeah. You can do definition. I don't know.
Well, she was off on the transfer load. They bring her back here. She had a positive meth back in July last year. But other than that, just failed report and failed pay. Carol, yeah. Yeah, the report here.
She wants to report.
Yeah, that'd be best.
And then sometimes you don't report it to me the same day we have counseling. Afternoon, Your Honor.
Good afternoon. Mr. Manning, is this Ms. Paul?
Judge, this is Ms. Stevens. I just got a point on a case
Okay.
yesterday or the day before.
All right, this is cause number CR 23-102, State of Texas versus Alexis Shea Stevens. On the state's motion to adjudicate, the court has appointed the Honorable Jonathan Manning as counsel. The court will reset this for hearing on the motion to adjudicate to October 30th.
And Judge, if I am able to get a resolution worked out, which I'm in the process of doing, could we have her set on the 16th?
Absolutely.
Thank you, Judge.
All right, who's next?
Judge, this is Ms. Paul, and we are requesting
Hang on
to
just a
reset.
Hang on just a second. This is cause number CR 20-352, State of Texas versus Wendy Marie Paul. Now go ahead, Mr. Manning.
Yes, Judge. We've reached an agreement on her case and we request to set on the October 16th docket.
All right, court sets Ms. Paul for plea October 16th, 1:30.
Thank you, sir.
You're welcome, ma'am. Who's next?
Next, we have Mr. Harrison.
Cause number CR 24-137, State of Texas versus J. Randall Harrison. Motion to revoke. Go ahead.
Judge, we were originally set for a contested motion on the motion to revoke. However, my understanding is the state has a witness that's unavailable, and we've agreed to a reset. I've conveyed that to my client, and he's in agreement with that.
All right, court will reset Mr. Harrison for contested hearing October 30th.
Thank you, Your Honor.
At 1:30.
So, you have to change their mind. I'll let you know if they change their mind. Finally, Judge, I have Mr. Jackson.
Jaquavian Antron Jackson, CR 21-361. Go ahead, Mr. Manning.
Judge, we have a plea. I believe you should have that in your queue.
Okay. All right, Mr. Jackson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Lower your hand. Speak up loudly and clearly for me. All right, Mr. Jackson, it appears that you were before the court previously on April 12th of 2022. And you pled guilty to possession of a controlled substance greater than 400 grams. The court heard the evidence that day, found that there was enough evidence to convict you. However, the court followed a plea agreement and placed you on deferred community supervision for 3 years. It was during that period that your community supervision was also extended for an additional 2 years. And during your period of community supervision, the state has filed a motion to adjudicate and revoke, and they have alleged 11 separate allegations of violations. Have you had enough time to review that document called the state's motion to revoke with your attorney, Mr. Manning?
Yes, sir.
And do you understand everything that you have read and signed in your plea agreement today?
Yes, sir.
And are you pleased with Mr. Manning and the work that he's done as your attorney?
Yes, sir.
Do you have any questions about anything before we go forward?
No, sir.
All right, I do see that there's an agreement in the case to resolve this motion revoke upon your plea of true. It appears that the state is recommending that the court convict you, that your community supervision be revoked, and that your punishment be assessed at 4 years confinement in prison, with you being ordered to pay the balance of your financial obligations, which includes a $2,500 fine, $180 in restitution, and $243.88 in reimbursement fees. Mr. Manning, how much time is Mr. Jackson entitled to on credit?
Judge, after looking at the calculations, we've agreed that 249 days are the appropriate amount of credit for this case.
All right, so Mr. Jackson, you would receive 249 days credit towards that sentence. Is that what you're asking the court to approve today?
Yes, sir.
Mr. Manning, do you believe Mr. Jackson to be competent to enter into this plea agreement, and if so, that he's doing so intentionally, knowingly, and voluntarily?
He is competent. I do believe he's entering into this plea intentionally, knowingly, and voluntarily.
Is he intending to plead true to all 11 counts and also waiving the formal reading of the motion?
That is correct, Judge.
All right, Mr. Jackson, I've explained to you the range. I've explained to you the plea agreement in your case. And at this time, I would ask you, how do you plead to the 11 counts alleged in the state's motion to adjudicate? Are those 11 counts true or not true?
True.
And Mr. Jackson, has anyone threatened you, forced you, or pressured you to plead true to any counts here in court?
No, sir.
All right, the court will accept the defendant's pleas of true to each count as alleged. Mr. Manning, any objection to the court admitting the evidence?
No objection to states one.
All right, that is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, then based on the evidence before the court finds that Jaquavian Antron Jackson has violated the terms and conditions of his community supervision. Court finds all 11 counts to be true. The court will follow the plea agreement today. The court hereby adjudicates the guilt of the defendant, convicts him of possession of a controlled substance of penalty group 2 greater than or equal to 4 grams, less than 400 grams, a second-degree felony. The court revokes community supervision, assesses punishment at 4 years confinement in the Texas Department of Criminal Justice, and orders the defendant to pay the balance of his financial obligations. The court awards Mr. Jackson 249 days credit towards his sentence for the time he's already spent in jail. Mr. Jackson, once you are released from prison, if you have not paid off your fines, fees, and other costs, then you're to report to the Van Zandt County Courthouse to make arrangements on a payment plan to discharge those. Failure to do so could result in the court issuing a warrant for your arrest for that failure. Okay?
Yes, sir.
All right. I'm going to have you go over with the deputy to be fingerprinted. Good luck to you, sir.
Judge, I believe that concludes my business. Might be excused.
As long as my supervisor, Ms. Abraham, says it's okay, then yes, sir.
I got the thumbs up, Judge.
All right, then you're good to go. You better walk fast.
Thank you.
All right, Mr. Schmidt, who are you ready on?
Jaden Hester.
All right, this is cause number CR 25-121, State versus Jaden Ray Hester. Is this a plea today, Mr. Schmidt?
It is.
Just a moment.
Where's? Seriously?
That's right. I got it. waiver or? No, it wasn't, it didn't have my name next to it.
All right, Ms. Hester, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Your name is Jaden Ray Hester, is that correct?
Yes, sir.
And Ms. Hester, have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes, Your Honor.
Do you understand everything that you have read and signed today that's part of your plea agreement?
Yes, sir.
All right, Mr. Schmidt, do you believe Ms. Hester to be competent to enter into a plea agreement? And if so, that she's doing it intentionally, knowingly, and voluntarily after understanding her rights that you've explained to her?
Yes.
All right, Ms. Hester, it appears that you were indicted with a second-degree felony offense of possession of a controlled substance in penalty group 1 or 1B, greater than 4 grams, less than 200 grams, and that does carry a range of punishment of not less than 2 years or more than 20 years in prison, and a possible fine not to exceed $10,000. I see that the plea agreement in your case is upon you pleading guilty. The state is recommending that the court consider the evidence, convict you of the offense, and assess your punishment today at 5 years confinement in the Texas Department of Criminal Justice, along with a $1,000 fine, plus court cost of $290, restitution of $180, and reimbursement fees of $120. Mr. Schmidt, what credit time, if any, is Ms. Hester entitled to?
20 days, Judge.
20 days. And so, Ms. Hester, if the court followed the plea agreement, you would receive 20 days credit towards your sentence for the time that you've already spent in jail. Is that your understanding of the plea agreement?
Yes, Your Honor.
Do you have any questions about about your plea agreement or anything else?
Would it be under 1 or 1B?
The judgment says 1 or 1B, so I'm not quite certain. I'd have to, let me go down and look at your stipulation.
Because it's not banned out.
Okay. No further question.
You sure? Okay.
Yes, sir.
All right. Understanding the range of punishment in your plea agreement, Ms. Hester, this time I would ask you, how do you plead to that offense?
Guilty?
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
And Ms. Hester, has anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
Court does accept the defendant's plea of guilty at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No, Judge.
All right, the court admits the evidence and takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Mr. Schmidt, anything further from the defense?
No, sir.
All right, court will review the evidence at this time. All right, the court has reviewed the evidence, finds that there is enough evidence to convict the defendant of the offense. The court will follow the plea agreement in this case. The court hereby convicts Jaden, Ray, and Hester of possession of a controlled substance in penalty group 1 or 1B, greater than 4 grams, less than 200 grams, assesses punishment at 5 years confinement in the Texas Department of Criminal Justice Institutional Division. The court awards her 20 days credit towards that sentence for the time that she's already spent in jail on this cause. Further, the court orders her to pay a $1,000 fine, $180 in restitution, $290 in court costs, and $120 in reimbursement fees. Ms. Hester, when you're released from TDC, if you are not, if you've not already paid off your fines, court costs, and fees, then you're ordered to report to the Van Zandt County Courthouse to make payment arrangements, okay?
Yes, Your Honor.
All right, I'm gonna have you step over to be fingerprinted.
Thank you.
You're welcome.
I can respond to you. Thing to get something done real quick, Phillips. Get after. It's good like that, we'll get up and do that.
Judge, I didn't run fast enough.
That's on you, man.
Judge, if I may, Mr. Randall Posey.
Yeah, just a moment. I gotta finish signing some plea papers here. All right, this is cause number CR 25-53, State versus Randy Glenn Posey for arraignment. Go ahead, Mr. Manning.
Yes, Judge, I apologize. I was also appointed on this case earlier this week. Mr. Posey has been provided a copy of the indictment. His name is spelled correctly. He understands the charge against him as well as the range of punishment, pleads not guilty, and requests to be set on the pretrial docket.
All right, the court finds that the defendant, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets this matter for pretrial hearing.
And if you'd like to set on the 16th date, I should be able to take a look at the discovery since it has been indicted.
Okay, so October 16th.
Yes, Judge.
All right, court sets Mr. Posey then for pretrial October 16th at 1:30.
Thank you, Judge.
You're welcome. All right, Mr. Schmidt, who's next?
This is Kendrick Willis.
Right, this is cause number CR 19-211, State versus Kendrick Willis. Motion to revoke. Go ahead, Mr. Schmidt.
Judge, we'd ask to set Mr. Willis on for a plea on your next, I guess, the next Tuesday docket.
All right, court sets Mr. Willis for plea before the court on October 14th, 1:30. Who's next?
This is Alexis Nava.
This is cause number CR 20-185, State of Texas versus Alexis Nava. Motion to revoke. Go ahead.
Judge, the same announcement asks to set Mr. Nava for a plea on the October 14th docket.
All right, court sets Mr. Nava for plea before the court October 14th at 1:30.
Hey,
Is Mr. Eddington the last one?
yes, sir.
This is cause number CR 22-132, State of Texas versus Keith Allen Eddington. Motion to revoke. Go ahead.
And Judge, we're going to ask for a reset onto your next your contested docket. On the state's motion, there are 3 counts. 2 are minor technicals that are quite old. 1 is a allegation of a second-degree felony. I know Mr. Hartwell has made attempts to give me access to the discovery in that pre-indictment so that we could take a look at it. And we're having problems with that, but we're not prepared to proceed on the state's motion until we get that new offense either resolved or wrapped into this business here.
Is the new offense indicted?
Your Honor, I don't believe it's been indicted yet.
Okay. All right. Court will grant the defendant's request and reset Mr. Eddington, and we'll carry him to the October 30th docket. that all you
Yeah.
have, Mr. Schmidt, other than the writ?
Yes, sir, I believe that's correct.
Mr. King, are you ready?
Yes, Your Honor.
All right, you have Mr. Cunningham with you, correct?
That's correct, Judge.
All right, this is cause number CR 25-94, State of Texas versus Jeremy Flynn Cunningham. I believe that we're set for pretrial. Go ahead, Mr. King.
Your Honor, this is my first appearance with Mr. Cunningham. I haven't had an opportunity to have a discussion with the state as far as a plea bargain offer and discuss the discovery and that sort of thing. I just request a reset to your next docket call so that I can have that opportunity to speak with the state and relay the offer to my client and be able to determine next steps after we do that.
Do you anticipate the need for any type of contested pretrial motions, motion to quash, motion to suppress, anything of that nature?
Not at this time, Judge. I've received the discovery. I have not watched all of the videos at this time, so I cannot completely rule out a motion to suppress, but at the moment, I do not anticipate having that.
How much time do you need? I've got a couple dates remaining in October. I've got two that are only about 2 weeks away, the 14th, the 16th, or I can
I
move
am
it to the
available.
28th.
I am available the 16th is it an afternoon docket?
If
16th?
if Mr. Cunningham is in jail, then yes, it'll be in the afternoon. If he makes bond or bail, then it'll be in the morning. Also got the 28th available if you need more time.
Let's do the October the 28th. That would work.
Okay. All right. Court sets Mr. Cunningham for pretrial. I'm sorry, for docket call October 28th at 1:30.
Thank you, Judge.
You're welcome.
Thank you, Judge. May I be excused.
Yes, sir. Thank you, Mr. King.
Thank you, Judge. Okay. Well, I think
Ms.
you're doing
Abraham,
fine.
Ms. Abraham, has Mr. Schmidt already left?
No.
Sir,
Hey, do we need to bring Mr. Drennan over for it was just it's a writ hearing on bond, right? It's not a writ hearing on probable cause, right?
Judge, I think that our writ hearing is gone from bond to probable cause, so
Oh.
I don't know that my writ was specifically filed for probable cause, but we're addressing that.
Okay.
And we've got.
Okay. I was just going to say if it was just bail, we could go ahead and do it there. But if it's probable cause, then bring him on over and we'll do it in person.
Yes, sir. Thank you.
okay,
All right. Thank
be
you.
there in a minute.
Thank you, ma'am. All right, court is on record in writ number WR 25-32, Wayne Drennan versus State of Texas. Mr. Schmidt, are you ready?
Yes, sir.
You're ready. You may proceed.
That's correct, Judge. I think that when we started this writ the last time, ultimately the writ was an agreed writ for personal bond. When I met with the state, Mr. Harlow and I discussed the contents of the arrest warrant affidavit. And both of us had agreed that the affidavit was appeared to be flawed. It appeared to lack probable cause or at least sufficient information to substantiate eyewitness identification of Mr. Drennan here. We proceeded with our writ and the court requested additional information. So today what we have done is we have had the alleged victim meet with law enforcement and conduct a photo lineup. And we're prepared to offer evidence to the court as to the results of that photo lineup identification and proceed.
Okay.
And I would allow the state to call its witness unless the state wants me to.
State can call. Your Honor, state calls Aaron McLeish.
All right. You know where you're going?
I believe so, Your Honor.
You'll raise your right hand. You know, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Steph, have a seat. You may.
Investigator McLeish, I'm handing you what's collective states writ 2. Before we begin, though, for the record, could I please have you state your name and spell your last name?
Yes, sir. It's Aaron McLeish. My last name is McLeish.
And Investigator McLeish, how are you presently employed?
An investigator with the District Attorney's Office here in Van Zandt County.
And today I asked if you could perform a photo lineup regarding this case. Is that correct?
Yes, sir.
Are you qualified to conduct a photo lineup?
And Judge agrees to witnesses' qualifications as a peace officer and her qualifications as far as investigative procedures, including photo lineups.
You accept the relation?
I do, Your Honor. Thank you. And Investigator McLeish, did you actually conduct a photo lineup with the alleged victim in this case?
Yes, sir, I did.
And can you tell me, as a result of that photo lineup, was the witness, Mr. Wiseman, able to identify a photo of the person that attacked him?
He did identify a photograph.
And I've handed you states exhibit 2 collectively. I believe it's marked states A, 2A through 2M. Can you tell me what is 2A?
2A is actually the set of instructions that come from the Texas Department of Public Safety regarding the photo lineup and the administering of such, as well as the instructions that an investigator is supposed to read to a prospective witness.
And 2B through M, are those the actual photos that Mr. Wiseman inspected?
They are, yes, sir.
And did you get the full name of the victim in this case?
Timothy Sizemore, yes, sir.
Sizemore or Wiseman?
I'm sorry, Weissman. Yes, sir.
And where did you meet with Mr. Wiseman?
In the witness room here at the courthouse.
Okay. And about what time?
About 1:30 this afternoon.
Okay. And for the record, today is October 2nd, 2025. So Mr. Wiseman did in fact make an identification in those photographs?
He did, yes, sir.
Can you tell me of states 2B through 2M, which of those photographs he identified?
Ultimately, he identified Exhibit 2B as the person that was at the scene.
Did he identify any of the other photographs?
He did, yes, sir.
Can you tell the court which other photograph?
That would be 2C.
And can you go ahead and remove the photograph from 2B?
From 2B?
Yes, please.
Yes, sir.
And for the record, the person arrested in this case, Mr. Drennan, can you identify where he's seated in the courthouse?
I can, yes, sir. He's to my left wearing the orange top.
And Your Honor, may the record reflect that this witness has identified Mr. Drennan?
Record will reflect that this witness has identified the individual Dwayne Drennan here in open court.
And Investigator McLeish, is the photograph contained in 2B a photograph of Mr. Drennan?
Not in my opinion, it is not, no, sir.
And can you pull the photograph from Exhibit 2C, please? And is that photograph a photograph of Mr. Drennan?
No, sir, it is not.
How confident would you be in saying that those two individuals in the photographs are not Mr. Drennan?
I'm 100% confident that these are not this gentleman here in the courtroom.
And those are in fact the individuals that Mr. Wiseman indicated to you attacked him in this case?
That is correct, sir.
And to be clear, Investigator McLeish, there weren't two people who attacked him. It was one individual who attacked him.
I'm sorry, Mr. Hartwell, I'm not familiar with any of the details of the case.
And your unfamiliarity with the case, is that one of the reasons why you were asked to conduct the photo lineup?
That is my understanding, yes, sir.
State passes the witness, Your Honor.
No question, Chair.
Board has a couple of questions. Investigator McLeish, can you tell me about Mr. Wiseman? Did he wear glasses, contacts? What is his age? Did he appear to be in any kind of state of concern during the photo lineup? Is there anything that this individual in his behavior or the way that he viewed the lineup would give you cause for concern as to his competency or anything of that nature?
Yes, Your Honor. I did not see him wearing glasses. I did not ask him if he wore contacts. He did not express any concerns to me about this process. However, initially at our introduction, he did explain that he has recently suffered a heat stroke, which at the very least has incapacitated his communication to a degree. I asked him before I administered this lineup if the effects of the heat stroke would impair his ability to make an identification, and he told me no. However, at the end of the process, he had to sign a document. And so I asked him to please remove the document, and I showed him on the document where I wanted his signature, and I even marked it with an X. And he took a considerable amount of time before signing it, scrutinizing my location, and then he made the comment that since his heat stroke, he had a difficult time seeing. And of course, we're in here asking him to look at photographs to make an identification. So I repeated my question to him. I said, you're having a hard time seeing. Are you able to make this identification? He did answer affirmatively, confidently affirmatively. He said, yes, I can do this. But it did leave me with some doubt that he was having a hard time seeing a blank that I had just indicated to him for his signature.
And let me ask, 'cause I don't think it was asked before, was the defendant's photograph actually contained in the lineup that you presented, or was the defendant's photograph not contained in that lineup?
Your Honor, I do not know the answer to that. I haven't looked at any of these photographs except for the two that I was just questioned about.
Your Honor, I can answer that. I believe it is 2D, I believe is, if Investigator McLeish would like to open up 2D and make sure that it is.
That was the gentleman in the courtroom.
Is there anything else, Investigator McLeish, that you think would be important for the court to know regarding and I'm assuming that the way that the photo lineup was presented was a double blind, or was it a single blind? It wasn't a 6-pack.
Correct, Your Honor. It was a 12-pack. Investigator Crawford put the photo lineup together. Investigator McLeish had no part in putting the photo lineup together. That's why we had her administer it.
So there were 12 photographs on one sheet of paper.
No, Your Honor. I'm sorry, 12 individual photographs.
So it's a blind.
Yes, sir.
Sequential.
Sequential,
Yes, sir.
not a pack.
Correct.
Okay. All right. Anything else from the state?
Not at this time, Your Honor.
Anything else from the defense?
Not from this witness, Judge.
Thank you, investigator.
Thank you, Your Honor.
Your Honor, I apologize. State does offer, states, to, collective, or states writ to collectively.
No objection.
All right, there being no objection, states two is admitted.
Thank you.
Mr. Schmidt, I think it's still your writ and you defer to them to call a witness. Do you want to call any witnesses at this time?
Judge, I have witnesses that I can call to bolster the testimony that you just heard. If the court requires that, then I can. Otherwise, the sake of expediency, I believe that I've conferred with the state and they intend to make an oral motion to reject the charges against him. And if that's still the case, then we'd ask to proceed that way. I know that we started out written on PR bond, but obviously it's our contention that it is a misidentification of Mr. Drennan, and we would much prefer the charges be rejected than him out on bond. So if the state still intends to do that, then we would ask that they make that motion, and then we would call any additional witnesses.
State.
Yes, Your Honor. State does intend to, reject the charges at this time. I think at the point that we're at with the evidence that's been gathered today, more investigation is needed in this case.
All right, very well. Then the court finding that the state has indicated to the court that it is rejecting the prosecution of the charges. The court hereby releases Mr. Drennan from custody. Is he being held on any other charges?
He's got a hold from Dallas County Judge, but I believe that the only one, yes, sir.
All right, then the court will sign an order releasing Mr. Drennan on this charge. And state, can you provide me with a notice of rejection?
Yes.
Or a declination letter so that I can attach it to my order so that the sheriff's office is clear?
Yes, Your Honor. I'll work on printing that up before I leave today.
Okay. All right. If there's nothing further, then as soon as I get that, then I will go ahead and draft the order and get that sent today, Mr. Schmidt.
Thanks, sir.
Right. I believe that then concludes the court's afternoon docket. The court is adjourned.
Say again?